This conference will now be recorded.
This is going to suck, fellas, but this is something that we all need to understand.
No, man, you rather be a... home or grandma's house?
Grandma's house.
Peace to Yahweh. Peace to Yahweh. How everyone doing tonight? I hope everyone's doing wonderful, magnificent, and great. I know I am. And you are now at Consultation Wednesday with your boy Jonah Bay. So what up, what up, what up? Yeah, we got a 50% sale going on at jonahbay.com that starts tomorrow and all weekend. You see what I'm saying? Where you get 50% off, but there will not be 50% off on consultations, and it will not be 50% off on the 5 classes to executorship, right? So those are only 2 things that you will not get half price on, but half price sale starts at 12 a.m. And y'all can start buying y'all stuff. With that being said, the journey to being a true executor is off the chain. There's a lot of inherent traps in it where you're really gonna have to know what you're doing. Shaka Bay say peace, everyone. Peace to Yahuwah to everybody. So I'm gonna do a quick talk about let me get it open. We're gonna get back on where we was on last Wednesday. Equitable remedies. No. Trying to remember where I left off at. Okay, equitable remedies. See, y'all are going to have to go into court against these companies, and you're gonna have to do a notice of equity to these companies to get your inheritance. You're gonna have to fight for it. You know what I mean? So I said I might as well get y'all prepared in the whole 9. Trying to find out where I left off at. All right, I'm gonna start here. A trust or a use was a type of contract usually in reference to land which invented after the common law writs, which controlled the jurisdiction and procedures of the common law courts, had become fixed and unchangeable. A trust is a situation in which the common law ownership of property is given to a person, the trustee, to hold and manage for the benefit of another person, the beneficiary of the trust. Since there was no common law writ available to enforce a trust, and since the chancery clerks and common law judges could not change the law by inventing a new one without unconstitutionally usurping legislative power in Parliament, the Chancellor enforced them. It was clear to the entire legal profession that justice inquired the enforcement of trust and uses. So did you hear that? They could not deal with trust unless it went into equity court because trust law would go against the common law or the constitutional principles. And that's another reason why it proves that every time you go into court, you're in an equity court because they cannot control a trust without being in equity court because it goes against the Constitution and common law, as I've been telling y'all. Right? So let's go on. Thus, the beneficiary of the trust is said to be the equitable owner of the property in question. The trust, which is completely unknown in European law, is a magnificent device for managing property or companies in both personal and commercial settings. This device has been steadily refined over the century to serve more and more needs of society. In the area of contracts, justice required that each party receive consideration, that is, something of value for performance of his part of the agreement. The common law courts require proof of consideration flowing from the plaintiff to the defendant, the obligor, before the plaintiff and the obligee could recover on an oral contract. So, common law or contract law. Got to be two people that signs the contract, and they both got to give up valuable consideration. This is why I told y'all from the giddy up, you have never been in a contract unless you did it with a private person, your neighbor or some shit like that. If you was dealing with a corporation, that wasn't a contract. Both of y'all didn't sign. Both of y'all didn't have mutual obligations and consideration. Everything y'all do today, y'all started with applications. Application is a trust instrument. So therefore, you're in trust law and you're in equity court each and every time. Y'all been trying to compare apples to oranges, and these teachers weren't telling y'all the truth about you're not in common law, you're not in constitutional law, you have been in trust law, in courts of equity. All right? However, if the contract was in writing and under the defendant's seal, the written and sealed instrument was sufficient proof for common law recovery, even though there is no consideration. A sharp dealer would be able to take advantage of others by always having such an unfair bargain reduced to writing with an eye to the future litigation, relying on well-established common law precedents. So, that's what's been happening to y'all. They got something called a foreclosure. That means they set up an instrument to take your house before it even happens, and you sign it from the very beginning, circumventing the common law, just like we just read. All right, let's go on. The common law courts could not change their law, but the court of equity came to require the unconscionable obligee to forego his unfair gain. The courts of equity required that all contracts be supported by consideration on both sides. See, so if you're dealing with a bank in a mortgage company, equity court is going to have to is going to enforce them to show how they took a loss, how they gave equal consideration. Ain't that something? All right, it says the mortgage is a common law conveyance of land to secure a loan. The mortgage contract is written so that if the loan is repaid, the debtor gets his land back. If it is not repaid in full, the creditor keeps the land. Even if only one payment is not made or the payment is made only 1 day late, in many cases, a debtor may be in a technical difficulty only, but the common law courts must enforce the contract that was freely entered into by the debtor. To prevent such harsh results, penalties, and forfeiture, the courts of equity allowed the debtor to redeem his land by making the payments late, which appropriate additional interest. Thus, the equity courts have created what is called an equity redemption. To protect fair-minded creditors, the courts of equity allowed a creditor to come into the equity court and prove the hopeless insolvency of the debtor, and the equity should be foreclosed, the debtor equity and redemption. This would give the creditor clear title to the land being held as security so that it can sell it and recoup the amount of default on the loan. Contracts should be kept is well respected by society. Everyone's senses of justice will acknowledge that the equity of redemption is a fine-tuning by the courts of equity that results in substantial justice in the individual case where the debtor is acting in good faith but has had a bad bit of bad luck. In more recent times, the courts of equity have evolved a law of fiduciary responsibility, which did not exist in medieval England. Thus, administrators of estates, guardians, and mental competence and trustees are held to a higher standard of loyalty than the ordinary businessman. So, every business made you do an application. You had to give up your social and the name, which created a security. By doing that, you handed ownership of that security over to them as a trustee. Since they became a trustee, they had to do a 56 with the IRS as a fiduciary or trustee, right? So therefore, as we just read, the law of equity says that every fiduciary or trustee is held higher than the businessman. I tell you, it's the same now. Businessmen are the trustees of every application you did. All right? The equity jurisdiction of the Chancery Court grew in the 15th century, also to cure problems in administration of justice caused by various defects in the procedures. Mute your ass out. Why the fuck are you on my show and I can hear your background? What the fuck's the matter with you? Are you retarded? Every damn show they do some dumb shit like that. How hard is it to hit your mute button on your phone or your computer? How hard? And why do they do it every time? Stupid. Some people ain't built for this information. They can't even follow a little rule like follow the rules of this information. It's crazy. Y'all niggas is retards that do shit like that. Nigga breathing all hard and shit. What are you, true predator? The fuck? All right, I'm going to start it over. The equity jurisdiction of the Chancellor Court grew in the 15th century, also to cure problems in the administration of justice caused by various defects and procedures of old common law courts. One common law rule of evidence was that the party could not testify in the court as a witness. Much has been written about the aspects of the rule that a person can testify against himself, but we will consider here that a person could not testify for himself. Thus, where the only witnesses to transaction or the occurrence were the parties thereto, the person's injury could not prove his case in the court of common law because there is no admissible evidence. And since the plaintiff always has the burden of persuasion, the defendant would win. Did y'all hear that? In the common law court, you can't testify for yourself. And you can't incriminate yourself. Now, when y'all in court every day, they testifying, swearing in, all that, that's testimony. Right? That's because you're not in common law courts. Y'all have been in equity courts. Are y'all starting to see this shit clear as hell? Y'all been in equity courts and y'all weren't even trying to use equity by doing a bill of equity, by calling out that they were trustees. And you as a beneficiary and the grantor don't like the way they were in the corpus of the trust. These are things you're going to have to learn, like a bill of equity. Thus, if one were assaulted in a dark alley, one had no practical remedy at common law. To aid the injured party, the courts of equity were defendant was required to plead under oath, would allow a person with a common law grievance to sue in equity in order to enforce the defendant's response under oath and discover, make known the truth, and then this sworn statement constitute a binding admission for use in common law court. In time, the courts of equity where discovery was needed began to retain the case and decided the common law dispute to avoid the municipality of litigation that would have been involved by sending the plaintiff back to the common law court. This was the origin of the Bill of Discovery. Y'all heard that? Discovery was created because common law couldn't handle issues, so they had to put it in equity and then do discovery. That's real. One of the most glaring archaic features of medieval common law was a trial by jury. Although the criminal jury was usually up to the task, life was too complicated for the civil jury, or civil juries were seldom sufficient, educated, or experienced to understand complex issues of financial importance. Regardless of how good the jurors might have been, the jury system required a single verdict of liability or not, and if so, what damages. Thus, where there were multiple plaintiffs or defendants, one lawyer was inadequate to sort out for example, which the defendants might be liable for what portion of the damages in the courts of equity, which arose long after the common law courts had set upon the use of the jury as a tier of facts of the case. Y'all ain't getting jury trials. The judge is deciding the case. That's what it just said. You are in equity court. How many different ways Are we going to read and it's going to tell you you are in equity court and you are in there as an estate or a trust? These are the. With that being said, I'm gonna open up the call line a little bit.